Hi everyone, I want to explain one of the major legal issues in this federal lawsuit in plain language. At the center of this part of the case is a big question. Was this data center project supposed to be approved under the city's zoning rules without going through CEQA environmental review? The developer says yes. The city says more review was needed. That disagreement is one of the reasons this dispute ended up in federal court. Here's how the developer explains their position. First, the zoning. The land was zoned I-2 industrial, which is one of the city's most intensive industrial categories. That zone allows heavy industrial uses. It also allows what the code calls business, professional, and research offices. The developer argues that a data center, a facility that stores and processes digital information, fits within those permitted categories. From their perspective, that means the use was already allowed under the zoning rules. Second, the type of review. The developer says the project only required a site plan review, which is a process where city staff check objective standards, things like building height, setbacks, and lot coverage. They argue this kind of review is ministerial, meaning staff apply fixed rules, similar to a checklist. Under California law, ministerial projects are generally not subject to CEQA, the state environmental review law. So the developer's position is this. If the project was ministerial, the city could not legally require a CEQA study. Third, the 15-day rule. City code says the planning director must approve or deny a site plan within 15 days. If no decision is made in that time, an application can be considered approved by operation of law. The lawsuit claims that deadline passed without a decision. Based on that, the developer argues the project became approved automatically under the city's own rules. So that's the core of this dispute. The developer says the zoning allowed the project. The review was ministerial and the deadline passed. The city raised environmental and planning concerns and did not treat the project as automatically approved. Now, a federal court will have to decide whether the city was properly applying its planning authority or whether it went beyond what its own rules. So we're here at the Adam and Clark lot where the data center is supposed to be, and as you can tell over there at the sky, look, there's an airplane. Do you see the airplane? So there's a heavy industrialized area